What's up, everybody, and welcome back to another episode of The Lawyer You Know. And we are breaking down more of the Blake Lively v. Justin Baldoni saga here, as Blake Lively's team has tried to put a gag order basically and shut Justin Baldoni's lawyer up. Justin Baldoni's lawyer has continued to go into the media, has continued to talk about how this is all not true about his clients. They have the receipts, they have all the information, and they're going to release it to the public. They want the public to see what actually happened. They want the public to see the context behind a lot of these words, a lot of these interactions, and a lot of what happened on set of It Ends With Us. And at the end of the video, we're going to talk about and show some of the footage that's B-roll or whatever you want to call it, that shows some of these unscripted interactions that Blake Lively complained about in her complaint that Baldoni's lawyer says add context. We're going to go through the letters to the court, what the attorneys are saying, and then we are going to look at the ethics rules in California and New York to determine if his lawyer is violating anything according to the rules of ethics in those states for what lawyers are allowed to talk about publicly about these cases. So make sure you guys hit the like button. Make sure you're subscribed to our channel. Let's get to it. So as I'm going to get into the first letter here that Blake Lively and her team sent to the judge, this is as part of there's so many complaints and stuff going on, which is kind of annoying. And another part that makes me feel like this is just not a real lawsuit, right? If you're thinking about how you want to do this and what's appropriate and what causes of action you have, you pick the proper jurisdiction, the best jurisdiction, you draft the lawsuit with the rules and statutes in place in that jurisdiction, and you move forward. I feel like we have so much going on in this case, so many different jurisdictions, types of lawsuits, different defendants, different plaintiffs, all connected in one way or the other. And it's just a little bit annoying from the process of, trying to teach and instruct and discuss how it works in the legal realm, because there are just so few cases that would ever be litigated like this. And that's what's frustrating and kind of annoying about it. And that's why I have such a hard time getting past, like, is this a publicity stunt at the end of the day? And Blake Lively and her team are trying to stop some of that publicity, right? They're trying to block some of it. They're trying to stop Justin Baldoni's lawyer from talking about it so much in the public. But before we even read a single rule, before we even read a single thing that anybody says or any lawyer says or any party says or any judge says, I will tell you, very, very rarely do judges or court systems allow you to use something as a sword and a shield, meaning you cannot go on the offensive and leak your lawsuit to the New York Times and have it go out there publicly and maybe even comment on it secondarily, which we'll talk about whether or not Blake Lively and her team have commented on it at all. You can't do that's a sword, right? That's you going on the offensive. That's you taking it to Justin Baldoni in the legal world and saying, oh, this is a lawsuit. These are allegations. We're saying they're true and we can prove them. That's the sword. But then you can't also use the legal system and the judicial system as a shield saying, hey, he can't talk about this. He can't come out and respond. He can't say X, Y, and Z because it may affect the case and it violates the ethics rules in California, New York, wherever we're talking about. We'll even talk about the American Bar Association, which is just kind of like nationally what a lot of these different states use to write their rules of ethics. That would be a shield, trying to stop somebody else from using the offensive, trying to stop Justin Baldoni from going on the offensive. Most courts do not like that. They frown upon using something as a sword and a shield. So I expect there will be at least some discussion of that when the court gets to it. But just because you filed a lawsuit, and even if you've commented on it publicly, if they find a lawyer is going too far, if they find a lawyer is doing things that are unethical or inappropriate, they will step in and they will stop that lawyer, and we will have some kind of gag order. So there are lines to all of this, but you have to make sure you be careful what you wish for when it comes to litigating things in the court of public opinion. All right, so let's get to what Lively and her team sent to the judge. Dear Judge Lyman, we write on behalf of plaintiff Blake Lively in the matter of Lively v. Wayfair et al. On December 20, 2024, Ms. Lively filed an administrative complaint with the California Civil Rights Department, a requisite step in exhausting her administrative remedies prior to filing suit. We've talked about that already. Usually you have to get a right to sue letter. You have to go through this process first. Kelsey's telling me I'm glitching again. This office internet is really rough. I will keep rolling with it and see if it gets any better. All right. I am going to try to keep going here. Hopefully we don't have to cut it and go to the house to finish, but We'll see. You guys let me know if it's working or not. All right, I'm going to keep going. People said it froze for a second. Okay, I'm back. Okay, we'll keep going. You guys let me know. There's nothing that annoys me more, as you know. I'm sure it annoys you too. Okay. Immediately thereafter, through counsel, Miss Lively provided the name of the defendants. I'm going to pull up my text here so I can see if John or Kelsey text me. Thereafter, through counsel, Ms. Lively provided the named defendants a copy of Ms. Lively's CRD complaint. At the same time, Ms. Lively also issued the Wayfarer parties a cease and desist letter demanding that they immediately cease and desist all unlawful conduct toward Lively Reynolds parties and their affiliates, including their harassing and retaliatory media and online campaign against Ms. Lively. So why is this important? Okay. The language that they're using here is not just a gag order because of the lawsuit. It's not just stop talking about it because you can't talk about the case. They're couching it in the things that we complained about as the Lively Reynolds plaintiffs is exactly what this lawyer continues to do. A targeted campaign against Blake Lively in retaliation for complaining about unlawful conduct. And it is continuing now through Baldoni's lawyer. That's what they're arguing here. It's not just the rules of ethics, which we will get to, which do govern how and when a lawyer can or can't comment on a trial or a case that they are litigating publicly. Immediately thereafter, and virtually every day since, Mr. Friedman, who is the Baldoni's lawyer, has given television interviews, appeared on podcasts, used inflammatory written statements, and leaked information, including, remarkably, documents as banal as document preservation demands to third parties, to the Hollywood press and tabloid media. I think that Mr. Friedman would even agree that he has been going on doing podcasts, doing interviews, all of that post the first lawsuit being filed. And I think he has a pretty good reason for it. We're going to wait until we read the defendant's response to really get into what he says his reasons are for it. Those statements not only continue the campaign of retaliation that was the subject of Ms. Lively's first cease and desist, but they contain numerous new false statements about Ms. Lively and others. So now we're getting into new territory. Is a lawyer going and publicly defaming and saying false statements that he knew or should have known are false about Blake Lively? Are there going to be lawsuits against the lawyer personally? We've seen it in other high-profile cases. I hope not, but we'll see. A list of public statements issued by Mr. Friedman, which is surely incomplete, is attached as Exhibit B. We've seen a lot of them ourselves. On December 23rd, well, I shouldn't say that are false, but he's made a lot of statements. On December 23rd, in light of repeated instances of Mr. Friedman making unprofessional and false statements about Ms. Lively and the litigation she had commenced, Ms. Lively sent a second cease and desist letter, this time directly to Mr. Friedman, attached as Exhibit C. The second cease and desist directly addressed Mr. Friedman's ethical obligations, notified Mr. Friedman, as well as the managing partner of his law firm, that he had defamed and engaged in further unlawful retaliation against Lively, and demanded that he immediately cease and desist from making any further defamatory and retaliatory statements relating to Ms. Lively. The second cease and desist lays out Mr. Friedman's false assertions and the evidence contradicting them, as well as the text of the applicable California Rule of Professional Conduct 4.1. The second cease and desist letter further explained that Mr. Friedman's statements as part of an all-out media blitz to anyone willing to listen were unprotected by the litigation privilege. Since the Wayfarer parties and Mr. Friedman received the cease and desist letters, they have continued their harassing and retaliatory media campaign with almost daily media statements or other releases to the press. Earlier today, the Wayfarer parties leaked a video to the media that they have asserted is designed to refute the allegations made in the Lively case. Let's read footnote 2. Well, first footnote 1 with litigation privilege. Accord Gig Tech, this case said litigation privilege does not permit party to take advantage of the privilege by instituting a judicial proceeding alleging false and defamatory charges, only to then issue a press release publicizing those defamatory allegations. So basically what you can't do is file a lawsuit that says whatever you want it to say, even if it's not true, and then go comment on it publicly, and then later the lawsuit goes away. If you know it's not true, it can still be defamation. Okay, and then they link this video, and we're going to watch part of that clip together that he says is the video that Baldoni's lawyer is leaking, saying it proves that Lively's case is false. Even though those allegations are now before this court in not one, but two federal complaints, they have further indicated that they intend to create a website to increase publicity around the exhibits filed in the Wayfarer case. So what he has said is, I want to make it all public because I want you guys, the public, to see it. I want you guys, the public, to be able to make the decision around the context of what was said, how it was said. That's why I want to create this lawsuit and make it all public. And Blake Lively is saying that's nefarious. He's trying to do this to defame her, et cetera, which we'll see. We'll see. Since the Wayfarer parties, sorry, I read that already. In one of today's multiple statements, they stated that the website will contain all correspondences as well as all relevant videos that quash her claims. Let's read the next footnotes. Or these are just the links. Okay, these are the links to his public comments. As counsel for Ms. Lively has made clear, these releases only reinforce the claims Ms. Lively advanced in her original complaint and continue to advance the campaign of retaliation alleged therein. But there is a more fundamental problem with Mr. Friedman's litigation via press statement strategy. As Ms. Lively's counsel have attempted to repeatedly caution Mr. Friedman, federal litigation must be conducted in court and according to the relevant rules of professional conduct. Wayfarer's counsel has already been warned that Mr. Friedman initial media blitz back in December violated various California state rules. His most recent statements, coming as they do on the heels of having filed a federal complaint in this court, plainly violate Rule 3.6, we're going to read that, of the New York Rules of Professional Conduct, which prevents a lawyer who is participating in a civil matter from making an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative process in the matter. Here, Mr. Friedman is a lawyer participating in a civil matter before this court, yet he continues to make regular statements covered by Rule 3.6. His conduct threatens to and will materially prejudice both the Lively case and the Wayfarer case by tainting the jury pool, because his statements are deliberately aimed at undermining the character, credibility, and reputation of numerous relevant parties, and likewise includes information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence at trial. We're going to read those rules. But what's interesting is, if you're going to complain about tainting the jury pool as one of your complaints, right? Can I highlight this? No. Whoops. As tainting the jury pool, the court should say, and the defense should respond with, you leaked this to the New York Times. You pushed this out as much as you could. So to now say us commenting on it and defending ourselves in the media where you brought this case, right? If I'm arguing as Baldoni's team, how can you say we're tainting the jury pool? We're just trying to correct the record because you have tried to taint the jury pool. That's what I would expect them to, argue. So get in all your questions about this letter. We're almost done with it, and then I'll answer it before we go on to Baldoni's response. Thereby creating a substantial risk of prejudice, not just for Ms. Lively, but for numerous other parties in the matter. Mr. Friedman's conduct is by design, not by accident, and this court should consider carefully his history of litigating matters in the press when evaluating his request to be admitted pro hoc vice filed earlier today. So they're saying, you shouldn't allow him to practice in our jurisdiction, Judge. You should look at his reputation. He does things inappropriately. He tries cases in the media, and we don't want to do that here. It is California, but it is worth asking whether Wayfarer's lawyers have any intention of abiding by Rule 3.6. They keep citing Rule 3.6. We're going to read it in its entirety. Or whether they intend to continue selectively releasing evidence without context. Do you need context, right? We're going to watch some of the video that was released. Or an opportunity to be questioned on that evidence in the public domain. At the same time, they purport to litigate this matter in court. Rule 3.6, of course, requires parties to decide whether they want a jury of their peers to decide their claims or whether they prefer to let the court of public opinion do so. Doing both at once creates an impermissible risk of interfering with the judicial process, and it is not tolerated under New York law or the law of any other relevant jurisdiction. I'm going to read and then we'll read the footnotes. The court may exercise control over its docket and the litigants before it to avoid improper conduct by counsel, and it should do so here. They cite a case that says, following plaintiff's media engagements and pretrial publicity, adopting Rule 3.6 as an order of the court applicable to all counsel of record, and noting that any violation of 3.6 should be punished under Rule 16F of the Federal Rules of Civil Procedure and through other monetary sanctions. The Lively Reynolds parties intend to seek an appropriate protective order to govern further proceedings in this case. But given the imminent harm caused by Mr. Friedman's misleading and selective statements and leaks, we are respectfully requesting that this court schedule a hearing as soon as possible to address the appropriate conduct of counsel moving forward in these two related matters. So let's read the footnotes here. Although Rule 3.6D permits attorneys to make statements that would protect a client from the substantial and prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client, my guess is we're going to hear that from Baldoni's side. It's literally what they're going to say. We were just trying to protect our client from the substantial prejudicial effect of recent publicity caused by Blake Lively. That's what I expect them to say. This is inapplicable to Mr. Friedman's statements. Virtually none of Mr. Friedman's statements at issue were made in response to recent publicity initiated by others. Okay, not sure I agree with that. Virtually none of Mr. Friedman's statements at issue were made in response to recent publicity. Okay, sorry. Instead, his statements perpetuate the narrative he and his clients have advanced in the media to compensate for the insufficiency of their claims and in furtherance of the smear campaign that is the subject of Ms. Lively's pleadings. Nor has Mr. Friedman limited his statements to such information as is necessary to mitigate the recent adverse publicity. Now that litigation has been initiated, the selective leaking of discovery materials is not a responsive statement. It is instead an effort to taint the jury pool and is prohibited by Rule 3.6. So showing the evidence is going to taint the jury pool. I get the arguments about this, right? Like on one side, it's like transparency, let us see everything. On the other side, it's like if you know stuff is inadmissible, allowing attorneys to get it into the public record just to talk about it because now it's public record is not appropriate. Becky R said, is litigation privilege absolute or is there limits? There are some limits, and that's one of them. You can't put stuff into discovery and put some in the public record just so that you can go talk about it and say, oh, litigation privilege. You can't do that. It's inappropriate. It's unethical, right? It violates the rules of ethics. That's something lawyers should care about. Wayfarer's counsel have attempted to justify their media campaign by noting that after they received the first cease and desist, they were contacted by the New York Times with a request for comment on a story regarding the CRD complaint. Even accepting this as true, though, would not authorize Wayfarer's counsel to continue to seek to influence the outcome of the judicial proceeding currently pending before this court, neither of which had been filed at the time of the first cease and desist. In any event, I don't remember seeing him come out before the first complaint was filed, but maybe he was. In any event, on information and belief, counsel for the Wayfarer parties voluntarily provided the CRD complaint to the press before the publication of the New York Times. Interesting article, accompanied by Mr. Friedman's bombastic press statements and other details. That's interesting. The New York Times, despite the sequence of events, Wayfarer parties have initiated litigation against the New York Times for defamation for $250 million, while separately suing Lively Reynolds parties and others here for $400 million. While Friedman continues to threaten the media to sue them into oblivion, a vague group of unnamed others, all raising questions whether he is willfully seeking to intimidate witnesses from coming forward or otherwise chilling lawful participation in the legal process. Oh boy. Oh boy. All right. I don't see John and Kelsey star questions as we go because it's hard for me to see them when we read. But that's Blake Lively's team asking for the gag order and explaining how he's talking too much. He's threatening to post stuff on public sites. So what I think is this looks good for Baldoni, right? He's like, we want to make it all public. And sometimes lawyers can do this knowing that they can't actually do what they say they're going to do, that the other side's going to object because it does look bad for Lively in the court of public opinion, right? It looks like she wants to hide the truth and Baldoni wants to reveal the truth. That could be true. Or it could be that a lot of this stuff is inadmissible, not appropriate to share publicly, and he is going to do something that's not appropriate or not ethical. That could be true too. And that's what's going to be discussed in front of the judge, and the judge is going to have to make a call at the end of the day. Aren't gag orders for criminal, not civil? Gag orders can be for either civil or criminal. And we're going to read the rules that they're discussing here, specifically Rule 3.6. And we can read Rule 4.12 that he references. Okay. Andrew said, it appears the New York Times metadata on the article is dated 2 days before she filed her CRD complaint. I don't know if that's true, but it wouldn't surprise me at all. Wouldn't surprise me at all. Rebecca said 3,000 in the chat and only 550 likes. Let's do better. Yes, everybody hit that like button, please. If you guys haven't already, we had a little technical difficulties in the beginning. So thank you for everybody that stuck around and is still here. Internet folks recently found that Lively's team sent the New York Times information before the complaint. How can Baldoni team proceed legally? So that's not illegal, but it does go towards the entire narrative that Baldoni and his team have here. So that would make sense and that would track if you believe Justin Baldoni. So we'll see. All right, let's get to the response from Baldoni and his team. As counsel for Wayfair et al., we write in response to the letter dated January 21st, 2025, which is what we just read from counsel from Blake Lively, Reynolds, Sloan, etc., concerning the extrajudicial statements. Contrary to the inflammatory allegations, they all keep saying everything each other's doing is inflammatory and bombastic and et cetera, et cetera. And I kind of agree with both of them. Contrary to the inflammatory allegations in the Lively's parties letter, counsel for Wayfair parties has not violated Rule 3.6 of the New York Rules of Professional Conduct. Rule 3.6a prohibits a lawyer who is participating in a civil matter from making extrajudicial statements that will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Putting aside that no such materially prejudicial statements have been made, Rule 3.6d creates an exception that allows a lawyer to make statements required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. So you can't create your own prejudice and then respond to it, obviously. That's why it has to be prejudice created by others. I think Baldoni's team has a pretty good argument that there's been a prejudicial effect and it's been pretty substantial based on things that somebody other than Baldoni and his team have done, aka Blake Lively, giving it to the New York Times, making sure it gets out there publicly before they even file it. That to me is what we have lawyers for, to respond, to defend their clients, to come, because I mean, listen, we heard it with the whole Puff Daddy thing. Everybody that stayed silent, most of the public came out and was like, why are they silent? Can you believe they're silent? Well, you could argue their lawyers would be like, hey, we can't come out and comment on it because that would be an extrajudicial statement that basically, I'll just tell you, every jurisdiction has something similar to Rule 3.6, and we're going to read California and New York, which almost exactly mirror the American Bar Association. So, this is in place in every case and every time you're accused of a crime, but you're allowed to make statements to protect your client from the substantial prejudicial effect of recent publicity. Okay, so let's remember that as a caveat, an exception. The Lively parties provided the New York Times with Lively's otherwise confidential administration complaint with the California Civil Rights Department and thousands of pages of original documents, including text messages and emails. In its bombshell story, We Can Bury Anyone Inside a Hollywood Smear Machine, the Times regurgitated Lively's allegations along with an array of cherry-picked, altered, and misleading spliced communications. The results have been utterly calamitous for Mr. Baldoni and the Wayfarer parties, who instantly became objects of public scorn and contempt. Already, the Wayfarer parties have been exiled from polite society and suffered damages totaling hundreds of millions of dollars due to Miss Lively's scorched earth media campaign. The coordinated public drop of Miss Lively's administrative complaint and the Times story, which the Lively's parties do not deny orchestrating, began a very much ongoing attempt to rehabilitate Miss Lively's image at the Wayfarer parties' expense. Immediately after the Wayfarer parties filed their complaint against the Lively parties, counsel for the Lively parties described the lawsuits as another chapter in the abuse playbook. So again, they're coming out and commenting. They're coming out and defending their client. They're coming out and doing the same thing. Baldoni's team is saying, you guys are saying we're violating 3.6, then this would be violating 3.6. As recently as 2 days ago, the Lively Parties Council publicly described the contents of the video footage relating to Lively's allegations as damning. Both sides say it's damning for the other person. Their statement continued. Any woman who has been inappropriately touched in the workplace will recognize Miss Lively's discomfort. So remember that when we watch this video clip together. You guys tell me, I'm not going to say I know how women would act when they're in discomfort in a work process. We're just going to watch it. You guys can say what you think it shows. I'll tell you what I would argue as the lawyer for both sides. In the context of a media feeding frenzy initiated by Ms. Lively, which has already caused and continues to cause untold harm to the personal and professional lives of the Wayfarer parties, counsel for the Wayfarer parties adamantly and in good faith believe that a public response is required in order to avoid prejudice to their clients. Rule 3.6, comment 7. Having publicly made ruinous allegations that the Wayfarer parties can prove are false, the Lively parties now invoke attorney disciplinary rules as an intimidation tactic. The Lively parties desire to force the Wayfarer parties to defend themselves privately against allegations made publicly is not a proper basis for the gag order. I kind of agree with that. It is a tactical game. It is tactical gamesmanship and is outrageous. If, as the Lively parties letter suggests, such a protective order is formally requested, it should be denied. We look forward to further discussing the matter at the initial pretrial conference scheduled for February 12, 2025. So this is about to start. This is about to go off. This is about to be in our living rooms, as they say, because these are situations where they are going to argue why they think they need this, why they think it's appropriate, why they think there should be a gag order, and why the other side thinks there shouldn't be. And that's all going to be something that we potentially can watch together, assuming there are going to be, or I guess federal court is not going to be cameras. So we'll have to get some reporting, people we trust, and go from that. Debbie said, I don't know why being a mean girl is relevant. Was she harassed or not? I agree. Mean women can still be harassed. I agree. And Baldoni seems to be avoiding responding to the worst of the accusations. I don't know if I agree with that. And again, we're going to talk about some of, I think I disagree with that. I think he has responded to some of the worst allegations, like things that he has said to her, whether it's about her weight or how he had her positioned and clothed or not clothed on set and having his buddy show up. He has responded to those. I'm not saying you have to believe the response or anybody has to believe him, but he is responding to some of the worst of the worst. The defendant showing up in her trailer while she's, breastfeeding or pumping or whatever. They have responded to them. I don't know if I'm not saying you agree with them or like them, but I do agree 100% with the first part of your statement that victims are not perfect, right? Some victims have done things in their past they're not proud of. Some victims have felony convictions you have to deal with. They can still be victims. So I do agree with that. Thank you to Susan and Azam and everybody gifting memberships today. Appreciate that. All right, so let's first take a look at the California Rules of Professional Conduct 3.6, trial publicity. A lawyer who is participating or has participated in the investigation or litigation of a matter, so it's even before litigation, shall not, those are strong words in a statute, shall not make extrajudicial statements that the lawyer knows or reasonably should know will, one, be disseminated by means of public communication. I think you can check that box. Everybody knew all of this was going to be disseminated, and have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So we can quibble about that. Baldoni's team is going to say, oh, no, I wouldn't, this would not materially prejudice anything or have an effect on any matter. I probably would disagree. I think they could materially affect it, right? They could prejudicially affect Blake Lively's case. It could be right. It could be necessary, but it still would check that box, which is why, again, we have caveats. We have exceptions. So we're going to get to some of them as we continue reading in the rule. Notwithstanding paragraph A, but only to the extent permitted by Business and Professionals Code section 6068, subdivision rule 1.6, a lawyer may state the claim, offense, or defense involved and, except when prohibited by law, the identity of the persons involved. So this is why I say stuff like This was overkill on this complaint. You didn't need to put all the text messages. You didn't need to explain every single thing. You didn't need to respond. He definitely 100% did not need to respond in his complaint to every one of the allegations made in Blake Lively's complaint. That is just not how we do complaints. An answer to that complaint, sure. A counterclaim to that complaint, sure, but not in a separate complaint. It's very weird and unusual to do that. But guess what? That is a way to publicly state all sorts of things you want to publicly defend yourself in the form of a complaint and to make it public record. That is part of the analysis in the lawyers in this case. Information contained in the public record, ding, ding, that an investigation of a matter is in progress. So then now that he's put in his complaint, and that's the kind of caveat they're talking about, is did he violate this rule by trying to circumvent it by putting it into the complaint, and it's just completely false allegations? I don't think they're going to win on that, because I think they have a good faith basis to believe the allegations they put in the complaint, and therefore it's public record, and therefore he's allowed to talk about at least some of it publicly. The scheduling a result of any step in litigation, a request for assistance in obtaining evidence and information necessary thereto, a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public, but only to the extent that dissemination by public communication is reasonably necessary to protect the individual or public. And in a criminal case, in addition to paragraphs 1 through 6, the identity of the general area of a residence. We can skip that. It's not criminal. Notwithstanding paragraph A lawyer may make a statement that a reasonable lawyer would believe is required. This is the big exception here, is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. So it can be initiated by Blake Lively, or even if you want to say she didn't initiate it, but the New York Times initiated it, that is still somebody that is not the lawyer or the lawyer's client. So therefore, they have a very good argument to me that he needs to respond to these statements. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. So this is something you can quibble about. Did Friedman go too far? Did Baldoni's lawyers say too much and do too much, or did he mitigate it as much as he could to just fit into this paragraph? No lawyer associated in a law firm or government agency with a lawyer subject to paragraph A shall make a statement prohibited by paragraph A. We'll read the comments here. Whether an extrajudicial statement violates this rule depends on many factors, including 1, whether the extrajudicial statement presents information clearly inadmissible as evidence in the matter for the purpose of proving or disproving a material fact, an issue. I think Lively's team can argue that, but they've got to prove that it is clearly inadmissible, which is not easy to do. Whether the extrajudicial statement presents information that the lawyer knows is false, deceptive, or the use of which would violate business and professional code section 6068 subdivision D or rule 3.3. So they can't lie. They can't lie. And if they do lie, they're going to be in trouble, right? You can't just use public record or use, I'm defending my client because of negative publicity, and then go lie or say something you know is not true, which of course Lively's team is arguing. Baldoni's team clearly will say that's not the case here. And just so you know, when something like that happens, when two sides say the other person's lying, we're both filing lawsuits, we're both pointing the finger at the other person, very rarely does a court step out, look from the top down and say, you are lying, that's clearly false, I'm going to sanction you. It's more of, let's see what happens, let's see what's proven out by the evidence, by the discovery, by the witnesses, the testimony. That's more than likely how they're going to determine what's true and false in this case. A judge isn't just going to look and say, oh, that must be false what Baldoni's lawyer said or what Blake Lively or her lawyer said. Number 3, whether the extrajudicial statement violates a lawful gag order, if one is in place, right? Then even though if it fits in this rule, if it violates a gag order, you're still in trouble, you're violating a court order. Or protective order, statute, rule of court, or special rule of confidentiality, for example, in juvenile, domestic, mental disability, and certain criminal proceedings. And the timing of the statement is also important. This rule applies to prosecutors and criminal defense counsel for additional duties of the prosecutor in connection with extrajudicial statements about proceedings. We can look at 3.8. Okay. So that's what the California rule says about it. Now that you guys know this, get in your questions. If you have questions, and let me know, do you think either of the lawyers' comments are violating these rules? When I read them, that's what I want you to think. What you've seen these lawyers say, do you think they're violating these rules of ethics and professional responsibility? Are they going too far? Are they doing things they should not be doing? Are they just going overboard, basically, in an effort to fix their client's public image? He hasn't really addressed the smear campaign Lively is alleging. He has. He has at length, right? Think about he's posting text messages saying, this is not us. We did not do this. Text message of him saying, I don't want it to look like we are doing this. Can we talk about this? I want to make sure we're not doing this. Right? He has addressed it. Again, I'm not saying you have to believe him, but he has at least addressed it and tried to come out and say, we weren't doing that. You guys did it to us. And then the smear campaign and the negative press was all because people didn't like you in your interviews. That's what he has said as far as a response to the allegation. Doesn't make it true, doesn't mean he's going to win, but he has tried to respond to everything, I think. People are saying he's playing in the gray. I kind of agree. I think that lawyers, what they're best at is using rules and statutes and words to fit their narrative and what they want to do, and what they think is right. And I think that this could potentially be a gray area. Thank you, Rebecca, for gifting 10 memberships. A lot of people saying, I don't think Friedman's violating anything. I definitely think it is an easy call that somebody else, New York Times or Lively, has put something into play that has created negative publicity that's very prejudicial against Baldoni, and lawyers have to stand up and defend their clients publicly. And I do think most of what he's doing is that. Did he go overboard at certain points? Is creating a website to post all the discovery and everything publicly on there going too far? It's interesting, and I've never seen it done before. So we'll see what the court has to say about it. All right. Here's rule point 3.6 in New York. Trial publicity. A lawyer participating in or has participated in a criminal or civil matter shall not make any extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have substantial likelihood of materially prejudicing an adjudicated proceeding. He is allowed to do these things. I guess I'll just read it. I was going to skip some of the repetitive stuff, but maybe if I read it, you guys can see how similar these rules are state to state. A statement ordinarily is likely to prejudice materially in adjudicated process when it refers to a civil matter triable to a jury, a criminal matter, or any other proceeding that could result in incarceration. And the statement relates to. So how do we know? They kind of define more what materially prejudicing looks like. Or if it relates to the character, credibility, reputation, or criminal record of a party, suspect, or a criminal investigation or witness, in the identity of a witness or the expected testimony of a party or parties. Did he go after the character and credibility of a party? Lively, Reynolds, etc. In a criminal matter, we can skip. The performance or results of an examination or test doesn't apply here. Any opinions as to the guilt or innocence of the defendant doesn't apply here. I mean, kind of they did talk about guilt or innocence, but in a civil matter. Information the lawyer knows or reasonably should know is likely to be inadmissible as evidence at a trial and would, if disclosed, create a substantial risk of prejudicing an impartial jury, or the fact that a defendant has been charged with a crime unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until and unless proven guilty. So this is really important because just for our other cases that we cover, a lot of this goes to prosecutors. If you're going to talk about defendant being charged, you better say it's merely an accusation, presumed innocent until proven guilty. So many times they don't, and there's no repercussion, but we as lawyers, we all should agree. No lawyer should ever, some people get upset that I talk about innocent until proven guilty and they're presumed innocent, and I'm not going to say they're guilty yet. Let's wait what the evidence is. Let's wait till the trial. People get frustrated by that. I understand, especially if you think you know that they did it. Every single lawyer across the country should always agree with those statements. It is literally written into all of our rules. Provided the statement complies with paragraph A, a lawyer may state the following without elaboration. The claim, information contained in the public record, that an investigation of matter is in progress, scheduling a result of a step in litigation, a request for assistance in obtaining evidence, a warning of danger concerning the behavior of a person involved, all the same exact as California. In a criminal matter, we'll skip. And then these last two that are kind of the ones that I think Baldoni and his team are going to hang their hat on the most. Just D. Notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited in such information as is necessary to mitigate the recent adverse publicity. Now, Baldoni's lawyer could possibly say, like, this was such a huge bombshell, judge, that the only way I could possibly deal with it was by releasing all of this information exactly how I did it. Period. All right. And since they referenced Rule 3.1, I did not have this before. I did not read this before, but let's take a look at it together. I think I know what it is. State of California Rule 4.1, truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by the Business and Professional Code 6068, subdivision E1, or Rule 1.6. So very simply stating, this is the rule that tells lawyers not to lie, as if we should need a rule that tells us not to lie. But that's what this rule is. So they cited this rule and they cited Rule 3.6, which again is very similar. Can't make extrajudicial statements. Can't prejudice any matter, civil or criminal, that's in litigation or investigation, or even before it happens, or if you know charges are coming. Except there are exceptions, and the big one here is if major prejudicial negative publicity is coming because of someone's fault other than your client or the lawyer involved. Very interesting. Now, we will get to the behind the scenes clips, and you can watch the entirety of this on a bunch of different channels. I just want to kind of reference some of the facts in her complaint and his complaint that discuss what is shown in this, just this little chunk. It's a 10-minute chunk. They dance, they talk. I'll just say, if I was Baldoni's lawyer, I think they can make a very good argument that Blake Lively does not seem uncomfortable. It doesn't seem like she's being harassed. It doesn't seem bad. It seems like she is having a good time, doing her job, making suggestions. I also think throughout the video, I'll reference some parts where, she says, make sure you get my high heels, don't crop my high heels out. And Baldoni's like, hey, make sure you don't crop her high heels out. Maybe he seems a little annoyed, but she doesn't seem like a bully. She doesn't seem like she's saying, absolutely not, do it my way or I'm walking. So, it's kind of like, it looks like everything was okay. I'm just going to say that's off like, and by the way, jurors trust their own eyes and ears more than anybody else's. That's why I love to hear what you guys have to say and what you see. Like I've said a million other times, in trials, I'll have a double board certified radiologist come up and read an MRI and say, this is where the disc injury is on the neck, explain it all to the jury. And then during deliberations, what do the jury ask for? Pictures of the MRI so they can look and see if with their eyes they can see an injury, because they trust their own eyes and ears more than anything else. So I think jurors, if this ever were to go to trial, would watch this and make their own determination, as just as you guys will hear, as to what they see and hear. So they basically start this clip by, she's like, what are they talking about? They should be talking. And he's like, well, no, sometimes me and my wife stare into each other's eyes. And she's like, well, me and Ryan just talk all the time, talk. And he says something like, that's cute. She's like, it's more than cute. It sounds like he was trying to compliment her. And she maybe thought it was like, oh, that's cute. How some people say that. And he's like, oh no, I think it's great. So again, neither one of them is forcing the other to talk about personal issues. They both seem perfectly fine discussing personal lives. Breaking character is something each of them was kind of accused of. It seemed like the audio was not going to be them talking here. It was like slow motion, dancing. A game was on. There's music on in the background. There's all sorts of things going on. It seemed totally appropriate and fine for them to try to act. They were both trying to act like they thought a couple in this situation would act. Now, every couple acts differently, which is kind of the point of the conversation. Baldoni's more like, we're more silent, looking at each other type. She's like, we're more talkative type, which is all fine. But this was part of her allegations against him. He would bring up personal issues. He would talk about his relationship with his wife, and it made her very uncomfortable. And we'll discuss some of the other allegations as we go through and watch parts of this clip.
I guess we don't shut up. And Emily and I have like,
and he's like, so she says, I know, or he says, I know you and Ryan talk all the time. And she's like, oh my gosh, we don't shut up. So read the captions. I personally think are the best way to get what they're saying.
Oh my gosh, we don't shut up. And Emily and I have like, we have these moments where staring. You just stare. Literally we've done it for like 5 minutes. it's like, I think you would find it terrifying. It's literally.
So I definitely think, sure, she looks like she's having a good time. But if again, this is just totally, you don't need legal opinion on this, but the overkill on the laugh to me is probably her acting for the scene to make it look like the character is having an amazing time and so in love. So it's like a mix. It feels like a mix to me. That's not legal analysis. That's just if I would have been sitting on a jury and somebody wanted my opinion.
We just literally hit each other and like time
a sociopath.
and like time stops.
Yeah.
But like that's just how it's been for us from the beginning.
No, we're like, oh my god, there's not enough time.
Oh.
And they score again.
Yeah.
Again.
It's like, oh my god, I forgot to tell you something else.
No, I think that's cute. You guys are really cute.
I think it's more than cute.
They won the Stanley Cup.
I think it's amazing.
Yeah.
You could tell he was kind of like surprised she was offended because he's like, that's cute. She's like, it's more than cute. And he's like, no, I think it's great. You know, it's like you can kind of catch that there might be a little tinge or a vibe there, but I don't know. Maybe I'm reading into it.
No, I think that's cute. You guys are really cute.
I think it's more than cute.
They won the Stanley Cup.
I think it's amazing.
Yeah.
And then let's just do one almost like super close.
Yeah.
Can you guys frame up on the Sebastian on you?
Yeah.
We'll just do like our lips are right next to each other.
Yeah, gotcha.
And again, that doesn't seem, first off, this is just me talking. It doesn't seem like a super overly sensual, like he was trying to do this to like add their lips getting close. And he's like, like talking to production, like we got to get this for the shot. Like we're going to get super close. Like he seems like he's working. That's what it seems like to me. She also seems like she's working. It doesn't seem like either one of them are not taking this seriously or, you know, things like that.
But I think it should start talking.
Okay.
Do you know what I mean?
Yeah.
Yeah.
Okay,
Isn't
ready?
it?
Again, she clearly thinks they should be talking. He doesn't. Doesn't seem like a bully to me. Maybe some people think it. This seems completely normal to me, which I think is probably better for Baldoni, but he also is saying that she's doing this stuff. So it's kind of like, again, at the end of the day, it's tough for me to see how anybody really comes out a winner in this case.
Don't give it to them. They want it. Don't give it to
They
them.
score.
Just keep restraint.
Yeah.
Score.
Just do a little bit of.
And if I'm just guessing the they want it, don't give it to them, that kind of thing. I think she means like the people watching want them to kiss, but don't kiss. I don't know. But if I'm just guessing, again, they're just discussing what makes the best scene, the most intense. And again, to me, everybody seems okay looking like, you know, we're almost going to kiss, not going to kiss in this type of a movie and these types of movies where people do this with each other, even though they're married to other people. It's normal in Hollywood. Like it seems like what you would expect in a movie like this. That's what I would argue if I was Baldoni's lawyer. Now, if you're Blake Lively's lawyer, it's already clear from their letter that they're going to say, oh no, she was completely uncomfortable. She felt like she was being harassed. She was trying to just make small talk to get it over with. She was trying to talk about something else that would make her more comfortable to distract him. She did not want to get close like this. He was adding too much of this in. That's what they can argue. And then the jury's going to watch and make their own determination.
They want it. Don't give it to
They
them.
score.
Just keep restraint.
Yeah.
Score.
Just do a little bit of restraint.
Right, come on back. And the couple by the bar walk towards us, cross. Who's that? Don't know your name, sorry. Ponytail lady.
And then.
Cross this way. Cross this way. Take your date. Cross this way.
It's so nosy.
I know.
It
And
just
my-
noses.
And my nose is so big.
Yes. I was hoping they.
All right. So this was another part that was in, I think, Baldoni's complaint, where he says the only person disparaging or being rude or mean about, you know, somebody's physical appearance was Blake Lively making fun of Justin Baldoni's nose, telling him he needs to get a nose job. And he's really self-conscious about that. So he made similar accusations like that as well. And what I will say is that's probably the closest thing to something offensive that was said is when she agrees that he has a really big nose. Like everybody's got friends with people or family members that maybe have a big nose. Maybe they're self-conscious. Like when they say they have a big nose, it's one thing. When you agree, it's kind of like, it's not super nice to do. But she does agree and she says, we can get that taken care of. She is clearly kidding, clearly not trying to hurt his feelings. Maybe she's uncomfortable, like he made fun of it. Maybe it's okay. Maybe you think you're good enough friends to make fun of something like that. So I do kind of think potentially he overstated that a little bit about how offended he was to it, because he definitely doesn't seem offended in the scene either. So, again, I think her team could argue that, but that's the closest thing to somebody offending each other I could see. But we'll listen to this exchange again here real quick.
I feel so nosy.
I know. And my nose is so big.
Yes. I was hoping that we could address this. It's not too late. Just gotta shut down. We gotta call an insurance month and just deal with that.
Yeah.
And then
God.
just kidding.
No, it's true. That's why we hired Jenny's late too. Our noses.
So she jokes, insurance shut it down for a month, have nose surgery. He's like, and she's like, I'm just kidding, because it was a joke. And he's like, no, seriously, that's why we got this guy our nose. It's like, is what it is. Like two friends busting each other's chops, right? That's kind of what it felt like. Let me answer some questions. What is the latest of the Jones work PR lawsuit? Could Steph Jones have been on the Wonder League? I don't know. I haven't looked into that one enough to answer that. Just BKZ. I think releasing evidence that's not vetted and which is manipulated is at least somewhat unethical. So was it manipulated? What do you mean by manipulated? Like taking some text messages and not others? Or, obviously manipulated would be like if they AI something, that's manipulated, but out of context, because you can do that in a complaint. I don't know. It's some gray areas for sure. Question, did Blake Lively officially submit her CRD or whatever it's called complaint? Yes, to that department, the Civil Rights Department, but she hasn't gotten her right to sue letter to file the complaint yet, as far as I know. I haven't seen that if she has gotten it. The thumb on the chin lip made it into the movie. I mean, yeah, that seemed like a totally normal, not over the top scene where they were trying to get the best shot and I say normal and not over the top. I have no idea what I'm talking about or doing when it comes to Hollywood scripts. So just take that with a grain of salt. Kimberly, Peter, does the applicability of the rules differ as to the public celebrity parties versus private? No. The only major difference is if it were me and somebody was accusing me of what they accused Baldoni for, there might not be any negative prejudicial publicity because people wouldn't care. But because it's Lively and because it's Baldoni and because the New York Times picked it up, because they're celebrities, there is a lot more of an opportunity for a negative prejudicial effect of the publicity happening. That's kind of the difference, I guess, between it being a celebrity. Peter, how is a case determined to be trial in state or federal court? And how does a case go to a grand jury? Do civil and criminal cases go to a grand jury, or is it only criminal? Just criminal goes to a grand jury, not civil. Different jurisdictions have grand juries, some don't. Some even that have grand juries, you still don't have to do grand juries. The lawyers usually determine whether or not they want to file a case in state court or federal court. I've gone through with my dad a ton of times. You have to have a federal nexus, a reason to file it in federal court. You can't just file any case you want in federal court, either somebody traveling across state lines or affecting a government agency like defrauding Medicare or something like that is something that can make it federal. In civil cases, a lot of times it's the case in controversy amount. The amount that you're asking for has to be above a certain amount to get to federal court, or you can't even get there. In certain cases, we'll argue the defense is now arguing our case is over $75,000. And it's like, well, that means great. Let's start at 75,000. Let's start the bidding there. So different things, just jurisdictional bars are what makes something go to state or federal court and the claims that you're filing. Some claims are appropriate for state court, some for federal court. Okay. The next part I want to listen to with no sound because there's music on in the background and you can't really hear them talking anyways, but I think the captions kind of give us the vibe of what we're talking about. And then we'll talk about what's referenced in the complaint. Just a lot of celebration. They just scored. Okay. Then he says, I'm going to have a hat on. I'm going to take it off. And then I'll try to kiss you and then I'll put it in there. And she says, great. Okay. Is he adding that scene? Is it ad-libbed? Is that something that made her uncomfortable? Could a victim say great after somebody does this to them because they're uncomfortable and they don't feel like they can say anything else? Yes, that is a possibility. But I think Baldoni's team think this is good for him because of the total context, the totality of the circumstances around it. That's really, I think, what their team is trying to show here with these clips. Okay. Now, this one specifically, I remember, as you guys probably do too, and you guys might find more things in these clips than, what I'm pointing out. But I specifically remember in Blake Lively's complaint, her saying he rubbed his lips all over me and was saying, that smells good. And it sounded really creepy, right? And it sounded like he was doing it at unnecessary times and in unnecessary moments. And from my perspective, that's something that could be creepy, right? That's like, oh, why are you doing that? Why are you doing that? But this scene to me gives a little more context, sheds a little more light on it. So we will take a listen to this.
Let's score another.
I'm getting beard on you today.
He says, am I getting beard on you today? So like, anybody who's got a husband or significant other with a beard and, rubbing up the neck, the face, whatever it is, sometimes it can be scratchy. Sometimes, or from my perspective, I get it. I've heard that. I think that's what he meant. Okay. And then here's the response that elicits the smell comment.
I'm probably getting spray tan on you. Well, it's not that. It's my body makeup.
So he says, I'm probably getting beard on you. She responds and says, I'm probably getting spray tan on you. And he says it smells good, which I disagree. I think spray tan smell disgusting. Which me and my wife, we have these conversations all the time. I scratch her with my beard. She gets a spray tan. I'm like, oof, not my favorite smell. But then she says it's the body makeup that smells good. It's like, oh, okay, great. Body makeup smells good. Cool. That seemed like a completely normal interaction to me and not something that he forced, right? That's just my perspective. And I could be completely wrong. You could see it differently. Other jurors could see it differently. But I do think that Baldoni said in some of his papers that there is a lot of this. There is a lot of this extra footage that did not make it into the movie that they say proves what the atmosphere was like. Was it a harassing atmosphere? Was it an appropriate atmosphere? Will Blake Lively's team say, and the problem is, so like before the list of things were signed that they agreed to, and they say it was a way more harassing environment, and then things were better after they all agreed when she came back to work. But she did list some specific instances. So if they can provide the video of the specific instances, that is going to be important. And usually we don't have video of interaction at work that one person is describing as harassment. So to me, I mean, this is something that could be very big and important in this case. You guys let me know what you feel like the video showed, because from my perspective, I think both sides will try to use the video. The entirety will probably be discovery, which is wild to think we're going to get this like behind the scenes. We got some of it from the Baldwin trial where we got to see some of those takes and the different stuff they said and, how they were holding the firearms and talking to each other. So that's kind of cool. We don't usually get to see behind the fourth wall. Is that what they say? So that would be kind of cool and kind of interesting and different to see. If it were me, if I was a lawyer for either one of these people, I'd be like, let's get together. Let's work it out. Let's have positive things to say about each other in the media and say, we've all apologized. We've all put it behind us. We're all trying to get better. And we can't wait to work on movie number 2 and suck it up and try to work on movie number 2 together. And maybe this will just be a big publicity push for everybody wanting to go see what their chemistry is like in movie number 2. Now, easy for me to say and totally inappropriate if somebody has been sexually harassed, right? To say, just put it behind you. That's not what I'm saying. I'm saying that based on the public opinion and the public discourse and the PR around this case. I just think it is going to be brutal from beginning to end. And I hate to see everybody get the scorched earth in a litigation and in the civil justice system. So We'll see how it goes on. We'll see what each side says. Athena says, I think she has issues with intimacy scenes in movies. It would have happened with any male actor. She's married, and intimacy scenes with men make her uneasy. I don't blame her. I wouldn't do it personally, right? If somebody said, in order to do YouTube, I have to, fake intimacy with some other woman, I'd be like, pass, I'm good. Thank you. Listen, to each their own, and she's going to do what she's going to do. But I think it's hard to have kind of both of those stances, is to choose to act in movies like this and then also say, you're making me uneasy or feel uncomfortable with intimacy scenes. Because nobody forces you to take a movie with intimacy scenes. Now, ad-libbing and doing things that are not in the script and having your buddy show up when certain parts aren't covered above and beyond, abnormal inappropriateness absolutely can be true. Rebecca, does she even look like she is being harassed? She doesn't even pull away. In fact, she laughs. And again, I think a bunch of different people could have a different way of looking at this, which is why it's so important to let people see it with their own eyes and make their own determination as to what they think happened. And that's what a jury will eventually do if we get there in all these different jurisdictions. She texted him the same day as the video was shot that he was terrific. I remember that. Yeah. She also invited him to her trailer less than 2 weeks after to run lines. Right. And again, I think there could be possibility, right? Like, it's like, I was in this environment. There's nothing I could do. I wasn't going to shut down the whole movie. So I pushed through and did my best. And, I was a warrior through it all, kind of thing. That could be how she says it, but I don't know. It's a tough one. It's a tough one, but this was a really interesting part of it. I enjoyed kind of this breakdown and discussion because it was on the rules of professional ethics. We see this in so many cases, lawyers coming out and speaking to the media. So we get to what the actual rules are, what's appropriate, what's not, where the exclusions are or the exceptions are, and where they're not. So that's a really interesting discussion because we're going to see more in the public eye in this case. We're going to see more in the Diddy and Jay-Z case. We're going to see more in a lot of these cases, the Karen Reed case maybe, where lawyers go out and talk in the media. What's appropriate, what's not. This will help us get our bearings and will apply to so many cases that we're going to be covering together on this channel. So I appreciate you guys being here. Please make sure you hit that like button. This one might be a tough watch the first 5 minutes because of the technical difficulty. So the like button will help push it out there on the algorithm to anybody that's interested in kind of this conversation. Mandy said, why would he sign the contract saying, I want to do X, Y, and Z? I won't do X, Y, and Z anymore if it wasn't happening. Would his attorney allow it if it wasn't doing said action? So there's been some discrepancies about whether or not it says I won't do X anymore versus this won't happen on set anymore. Or I have to look at what the exact language is, but I've seen people say it in ways that it makes it look more nefarious. Now, I agree with you, and I would never advise them to sign it. But I also tell clients all the time, it's your decision. You got to weigh the pros and cons. So if you don't sign it and the movie's dead, or if you sign it and it could come back to bite you, but you can make a movie to make $300 or $400 million, is that a risk you're willing to take? And maybe he would sign it anyways, and then it can be used against him, but he can still say exactly that. I signed it because I had no other recourse. She forced me into it. I was either going to lose the movie or sign this piece of paper. And again, a jury's going to have to determine whether that's true or not. I don't know the answer. I agree. I think that's a great piece of evidence for Blake Lively's team. Polly Claire, I wish Dave Halls and Baldwin got half of the hate BL and JB get. DH and AB actions killed a woman. We don't know Baldoni or Lively. Seems like 6 versus 1/2 doesn't. All right. That's all we got. I appreciate you guys joining in. Appreciate you listening. Appreciate you subscribing if you haven't already. But that's all we got. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.